I mentioned earlier that there is an affirmative obligation to investigate a complaint of sexual or human rights violation, one of which is sexual harassment. And also under the Occupational Health and Safety Act of most jurisdictions, there's further an obligation to investigate particularly allegations of workplace violence and harassment. Ontario statute requires the employer prepare a policy setting out its obligation and procedures for a complaint of workplace violence and harassment. It must be posted in a conspicuous place, reviewed annually, all of which is contingent upon the workplace having more than 5 persons. But most importantly, the policy must set out the steps which the employer will take to investigate allegations of workplace violence or harassment. And with respect to harassment, the policy must provide that any identifying data about the individuals concerned will not be disclosed unless it's required for purposes of investigating or taking other remedial action. So the suspected one may, for example, say, well, I don't know what this is about. I don't understand anything. I need to know at least who made the complaint, in which case likely that person should be told who the complainant is. The policy also must state how the worker and the alleged offender will be advised of the results of the investigation and any corrective action that's to be taken because of the investigation. Now, the Act speaks of incidents requiring an investigation, but it's not necessary that a complaint be filed for the employer to take such steps. If the employer is aware of it, then it should take investigative steps. And again, as I mentioned, most jurisdictions have similar legislation. PEI has a similar statute. Alberta does, Saskatchewan, and also Manitoba and the federal government. So these are things to be aware of. And if the employer does not comply with these objectives, there's all kinds of arguments available to the employee in civil court. The employee could argue, for example, well, the failure to put into place such a policy manual is a breach of statute. It should give rise to a constructive dismissal claim that I'll talk about later in terms of general realm of constructive dismissal. A claim perhaps for aggravated damages and punitive damages. So the employee has remedies, I suspect, and I'm postulating now because there's no direct cases on it, but it stands to reason the employee would have such civil remedies available where the employer is in breach of this obligation. So it's a formidable objective. The employer must comply, and if it doesn't, it's going to be in trouble.